Hi, my name is Gabrielle Wills. Welcome to my presentation of LGBT discrimination within the foster and adoption system. Imagine having raised your child for 4 years and suddenly finding out that to preserve your rights as a parent, you would have to pay the equivalent of thousands of dollars in fines, suffer through a criminal background check, and have a government employee scrutinize your home. All this just to adopt a child you've been raising all along. Sound far-fetched? It happens all the time. Now, imagine wanting to foster and eventually adopt a child, and you have everything going for you. A good job, a nice house, an experience with parenting. You know there are hundreds of thousands of children in the system that need a good home, but you're turned away because the agency handling the adoption doesn't like your lifestyle. And this happens at the next 3 agencies you visit.
It's been 50 years since the riot and demonstrations to protest police harassment against LGBT persons happened at the Stonewall Inn gay bar in Greenwich Village, New York. It was a defining moment that changed the public perception of gay, lesbian, bisexual, and other queer people.
Things have changed a lot since 1969, but not as much as people think. There is a surprising disconnect between public perception and the legal protections that LGBT persons actually have. According to a 2019 Reuters poll of registered voters, nearly half thought that federal law protected LGBT persons from sexual orientation discrimination, with over a quarter admitting they didn't know. The reality is that federal law does not expressly prohibit this discrimination, and fewer than half of states offer explicit protections for LGBT people at the state level. What this comes down to is the disparate treatment of members of the LGBT community who wish to become parents, or who are parents and want to have their relationship with their child recognized under the law. In a study conducted by the Human Rights Campaign and Clark University, the authors used data from 337 American LGBT individuals who had reported that they had A, attempted to become foster and/or adoptive parents, and B, encountered delays or disruptions they felt were specific to their minority status. The study found that significant and unjustified obstacles were placed in the way of potential LGBT parents. In particular, social workers with negative attitudes and assumptions about LGBT persons, and home studies that focus on heterocentric norms. For example, parents consist of one man and one woman. At the heart of the matter is people's perceptions about what makes an ideal parent. The laws that govern who is and who isn't considered a parent in this country are open to plenty of interpretation. Attorney Nora Udell uses the Dr. Seuss story, Are You My Mother?, to illustrate how a simple question of parentage has now become difficult to answer. She explains that same-sex partners have always faced numerous challenges to becoming parents, and that advances in reproductive technology, changes in the structure of family, and a legal system that frequently is behind the times have combined to turn a simple definition of what makes for a good parent into a complicated issue. Let's unpack that definition of complicated. What makes for an ideal parent? If you were to ask the average American, you might get answers like positive discipline, a good sense of humor, responsible, or experience. You might also get answers like a mom and a dad, religious devotion, or heterosexual. Herein lies the problem. Those last 3, they are just opinion and not based on scientific research. There is no evidence that being religious, having opposite-sex parents, or identifying as heterosexual makes for a better parenting experience. A study published in the Journal of Developmental and Behavioral Pediatrics found no differences in outcomes for children raised by lesbian parents compared to heterosexual parents on a range of outcomes including general health, emotional difficulties, coping behavior, and learning behavior. When my now wife and I decided to add a child to our family through IVF, the right of same-sex couples to marry legally had not been granted. At that point, we had already been together 5 years and had children from previous marriages. I was the person who chose the sperm donor, gave my wife over 200 fertility shots, signed off on the eggs being implanted into her, took care of her throughout the pregnancy, and was there when our little girl was born 6 weeks premature by C-section. It was a 2-year journey we traveled together. I am on the birth certificate, and we have raised our daughter together from day one. I must be her parent, right? Wrong. Only if I were a man, married to a woman. Since the beginning of 2020, only California, Massachusetts, Nevada, Vermont, and Washington have passed bills that allow me, as a woman, to declare parentage of the child of my partner, just as a man is able to in a voluntary acknowledgement of paternity, or a VAP. Those 5 states have made some form of the revised document available to include same-sex female parents and parents who conceive through non-surrogate assisted reproduction. Attorney Leslie Joan Harris asserts that it's unfair and discriminatory to not allow LGBT parents to benefit from the voluntary parentage system, saying, quote, "Unmarried same-sex partners who wish to establish legal parenthood between children and the partner who is not the biological parent have 2 equal protection arguments to support the claim that a voluntary declaration of parentage should be available to them. The first argument, available only to women, is that allowing men to establish paternity, but not allowing women to establish maternity, constitutes prohibited gender-based discrimination. The second argument, available to all same-sex couples, is that denying them access to voluntary declarations of parentage amounts to unconstitutional discrimination based on sexual orientation." End quote. Unmarried same-sex couples need a way to voluntarily establish legal parentage, and we need to stop discriminating against children on the basis of whether their parents are married or not. Future legislation in this vein would need to be at the federal level, because there are some states that will never pass laws that make equality in parentage of paramount interest. Case in point. According to the Center for American Progress, there is a lack of non-discrimination protection in the child welfare system, including the recent push by the Trump administration to allow religious exemptions for child placement agencies. Following the lead of North Dakota in 2003, 9 more states have passed laws that allow faith-based adoption agencies to turn away prospective parents for any reason. This is a foot in the door to widen discrimination against not just members of the LGBT community, but already protected classes as well. At a time when the number of children in foster care has increased more than 11% over the last 5 years, states can't afford to allow any potential foster or adoptive parents to slip through the cracks. The Center's recommendation for the future is for federal, state, and local governments to enact non-discrimination protections for LGBT potential parents and repeal agency religious exemptions. It is clear that the only way to secure the rights of LGBT parents and potential parents is to pass sweeping anti-discrimination legislation akin to the Equality Act of 2019, which passed the U.S. House of Representatives in May. It would prohibit discrimination against LGBT persons in areas long ignored by other statutes: housing, the workplace, public accommodations, and other settings, including adoption and parental rights. Unfortunately, it has not passed the Republican-controlled U.S. Senate, and even if it did, it would be unlikely to be signed into law by President Trump. But it is the first time anything like the Equality Act has passed an entire congressional chamber. Full passage could be just on the horizon. Until that day, there is the voluntary acknowledgement of parentage, which should have the same force of law as a court order, meaning it must be recognized by all U.S. states. To make it clear, however, that pervasive discrimination towards members of the LGBT community continues to exist, the National Center for Lesbian Rights, NCLR, has cautioned that until VAPs are available to people regardless of gender or genetic connection, they may be vulnerable. Quote, The NCLR strongly recommends that all non-birth parents get an adoption or judgment from a court recognizing that they are a legal parent, even if they are married, even if they are listed as a parent on the birth certificate, and even if they have signed a VAP." End quote. At the extreme, traveling with your child to a state or even a country that does not have the same VAP provisions could result in a charge of kidnapping against the non-biological parent. Defending the rights of LGBT parents brings security to families, and ensuring that anti-LGBT discrimination is kept out of the decision of who makes an ideal parent will increase the number of qualified applicants. What is most important for children is not a biological connection with their parents, but consistent and loving care. The net benefit could be to hundreds of thousands of adoptable children nationwide who are stuck in the foster system. I'm here to tell you, all those kids in foster care don't give a hoot about what your sexual orientation is. They just want a home. Thanks for taking an interest in my presentation, and I hope you enjoyed it. Bye-bye.